The topic of this panel is towards a new international law for the 21st century. Much of the law of armed conflict in existence today was developed in the immediate aftermath of World War II and in the Cold War. And there's no question that at the end of the Cold War and with the rise of militant Islam, these have presented new challenges to international law. And there's a growing consensus, as we heard in the last panel from Jack Goldsmith, that the Geneva Conventions are inadequate or at least ineffective in controlling the costs of the sorts of low-intensity conflicts that have developed since the Second World War. We have a very distinguished group of panelists today. I'll just introduce them all very briefly. John Bellinger is currently serving as the legal advisor to the Secretary of State. He previously served as senior policy advisor to Secretary Rice and at the White House as senior associate counsel to the President and legal advisor to the National Security Council. Between 1997 and 2001, Mr. Bellinger served as counsel for national security matters in the criminal division of the Department of Justice. And before that, he served in a variety of legal roles within the intelligence community and did a 4-year stint in private practice at Wilmer Cutler and Pickering. Mr. Bellinger received his A.B. from Princeton University's Woodrow Wilson School and his J.D. from Harvard Law School. He's also received a master's in foreign affairs from the University of Virginia. Next to him, we have Deborah Pearlstein. Deborah Pearlstein is a research scholar at Princeton University's Woodrow Wilson School, and Ms. Pearlstein has published numerous popular and academic writings on the Constitution, executive power, and national security. From 2003 to 2006, Ms. Pearlstein founded and directed the Law and Security Program at Human Rights First, where she led the organization's efforts in research, litigation, and advocacy surrounding U.S. detention and interrogation operations. Ms. Pearlstein also served in the White House as senior editor and speechwriter for President Clinton. She received her A.B. from Cornell University, her J.D. from Harvard Law School, and she clerked for Justice Stevens of the U.S. Supreme Court. Next to her, we have Gary Solis. He's a professor here at Georgetown. In addition to teaching the law of armed conflict here at Georgetown, Professor Solis is on the teaching faculty of the International Institute of Humanitarian Law in San Remo, Italy. Professor Solis taught on the law faculty of the London School of Economics before joining the Department of Law at the United States Military Academy. For 6 years, he headed West Point's Law of War program. He's published 2 books on the law of armed conflict and is currently writing a textbook on the topic for Cambridge University Press. Professor Solis received his BA from San Diego State, his JD from UC Davis, an LLM from GW, and a PhD from the London School of Economics. Next to him, we have Matt Waxman. Professor Waxman teaches national security law at Columbia Law School. He served as the principal deputy director of the policy planning staff at the Department of State, and before that at the Pentagon as the Deputy Assistant Secretary of Defense for Detainee Affairs, and unfortunately for him, as my boss. He also served on the National Security Council as special assistant to then National Security Advisor Condoleezza Rice. In addition to his government service, Professor Waxman has worked as a foreign policy and international law consultant to RAND. He's co-author of 2 books, as well as articles and monographs on foreign policy and national security issues. Professor Waxman is a graduate of Yale College and Yale Law School, and after law school, he served as a law clerk for Justice Souter on the U.S. Supreme Court. Finally, we have our David Cole. Professor Cole teaches constitutional law here at Georgetown and has written a truly stupendous number of articles in a variety of areas, including civil rights, criminal justice, constitutional law and literature. He is the author of 4 books, including most recently Less Safe, Less Free, Why America is Losing the War on Terror. After graduating from Yale Law School, Professor Cole served as a law clerk for Justice Arlen Adams of the United States Court of Appeals for the Third Circuit. He then became a staff attorney for the Center for Constitutional Rights, where he litigated a number of major First Amendment cases, and he continues to litigate major cases today. He's the legal affairs correspondent for The Nation, and in his copious spare time, he's also a commentator on NPR All Things Considered. So we welcome all of you. Thank you very much for being here. I'd like to start the panel by asking John Bellinger, as the representative of the administration, to share your thoughts on whether and how to reform the Geneva Conventions and other aspects of international humanitarian law, and then move on to get some reactions from the other panelists.
Great. Thanks, Matt. And I'll try to be short up front just to get the ball rolling. I guess first is the question, do they really need to be reformed? And I would first say really they don't need to be reformed. The Geneva Conventions are bedrock for all of us. They're bedrock particularly for the military. We absolutely stand behind them. In this great debate over the Geneva Conventions, it's been suggested the administration doesn't believe in them, thinks that they're antiquated, outdated, and that's not true. They absolutely apply in the places that they apply. So, for example, we have applied them in Iraq. The problem is that they do not apply to every armed conflict. There has been sort of a general sense, and I've spent a lot of time talking to Europeans about the subject, that, well, if you're in an armed conflict, then the laws of war apply. The Geneva Conventions is the principal law of war, ergo the Geneva Conventions apply. But as lawyers, if you actually look through the articles of the Geneva Conventions, Article 2 says that it applies to conflicts between state parties. It doesn't apply to anything. It applies to conflicts between state parties. The conflict that we have been in has been with Afghanistan and with al-Qaeda. Now, there's been a great debate about whether Afghanistan, which was certainly a state party to the Geneva Conventions, whether the Geneva Conventions did apply between them and the United States. I'm going to put that aside and just focus on the issue of al-Qaeda, because all of the members of al-Qaeda who were in Afghanistan represented a number of different countries. They were not fighting on behalf of a particular country. So the conflict between the United States and al-Qaeda was not a conflict between the United States and a state party, which generally meant that the Geneva Conventions as a whole didn't apply in their totality to that conflict. Now, the Supreme Court held that the common Article 3, an article that's common to the four principal Geneva Conventions, does apply to the conflict with al-Qaeda, but that provides only limited guidance to the other 120, 130 articles in the Geneva Conventions that provide guidance in a conflict don't apply, and only the one article by its terms applies. I won't go into all of the details there, but what it does is it leaves open then key questions as to, in a conflict with a non-state actor like al-Qaeda, as to what the rules of war ought to be. I gave a talk at Oxford last December in which I asked the key questions that a country needs to know: who can be detained, who is a combatant, what process is necessary to determine who is a combatant and who can be held, how long can the person be held, and what country do they need to go back to, are questions that in a traditional war are very clear. You know who's a combatant. They have a uniform on. You know how long you can hold them. You can hold them until the end of the war. You know how much process you need to give them. You generally don't have to provide a lot of process. If they've got a uniform on, there's a presumption that they are a combatant. But in these new kinds of conflicts between a state, the United States, and a non-state actor, the Geneva Conventions in their totality don't apply. Only the so-called Common Article 3 applies and doesn't provide a lot of guidance. So the Geneva Conventions don't need to be reformed, but what we do need to do as countries is figure out what additional international rules we need to have to provide guidance on those questions. Just a couple of points, and I'll turn it over to others. One, in conversations with Europeans, they tend to say, well, all right, you've persuaded me that the Geneva Conventions by their terms don't apply. If there are gaps in what it covers, we should fill them in through traditional principles of human rights law, which things like the International Covenant on Civil and Political Rights, or our own in Europe, European Convention on Human Rights. These are laudable principles. We would probably not disagree with a lot of the policy principles that would be provided, but at least Europeans tend to say, well, these apply as a matter of law. They fill in the gaps as a matter of law, customary international law in places that the Geneva Conventions don't extend. And I think you can get to some of the same places, but it's hard to say those principles apply as a matter of law. 2 points just echoing what I gather was said earlier this morning. I think there is growing recognition now that where it was believed that the United States had just clearly ignored clear rules in the Geneva Conventions, that the law is a lot less clear in this area, that the questions that I mentioned simply are not answered by the Geneva Conventions, and that countries need to work together to try to develop some new principles. I'm just going to read you 2 sentences from a study that was done by the British Foreign Affairs Committee of their Parliament on Guantanamo, which I will tell you was largely a quite critical study of the United States. But it did say on the point of the Geneva Conventions, we conclude that the government, that's the British government, should recognize that the Geneva Conventions are failing to provide necessary protection because they lack clarity and are out of date. We recommend that the government work with other signatories to the Geneva Conventions and with the International Committee of the Red Cross to update the conventions in a way that deals more satisfactorily with asymmetric warfare, with international terrorism, with the status of irregular combatants, and with the treatment of detainees. I think it would be too hard to try to immediately negotiate a new Geneva Convention. That's 194 countries around the world and would take a very long period of time. But we do need to recognize that the Geneva Conventions don't provide all of the answers that a country needs, and that we need to be working together with other countries to develop what those principles of treatment and holding of detainees ought to be.
Thank you. Ms. Pearlstein?
Yeah, thank you. Thanks to Neil, Kajal, and everybody here at Georgetown. It's really a pleasure to be here and an honor to be on the panel. Let me just respond, I guess, with the first few thoughts about the Geneva Conventions in particular. As I understand the argument in favor of developing new international standards in this area, whether it is, as a formal additional protocol to the Geneva Conventions or some, slightly less formal and involved instrument of international law, I think the most powerful ones from the administration are twofold, or the most important ones are twofold. One is are there adequate procedural protections, particularly as our own U.S. Supreme Court has now interpreted Common Article 3 as applicable to a conflict with al-Qaeda. I would footnote there, query whether the Hamdan decision was talking about the conflict with al-Qaeda globally or the conflict with al-Qaeda to the extent we were in a conflict with al-Qaeda just in Afghanistan. I think that's a rather significant question. But setting that aside for the moment, Common Article 3, quite right, is fairly broad in its description of what procedural protections, if not actual treatment, what procedural protections a detainee in a conflict might be entitled to, assuming the detainee is not a prisoner of war, a formal prisoner of war. And we can talk about that distinction in greater detail. So that's argument number one. Argument number two is, as I hear it, a sort of who can we really detain, and can we detain all the people we need to? In other words, a substantive matter of international power to detain people. So let me say, with respect to both of those, ultimately, I don't yet find them compelling. I am open to persuasion, certainly on the argument that it would be good to have some sort of greater international law procedural protection for detainees caught up in the course of international armed conflict, however, or national or non or international armed conflict. However, I am not yet persuaded, and let me address both of those points real briefly. With respect to the procedural protections, and I had occasion to read this statement, or this report out of the UK Parliament, which is indeed quite critical. And what struck me both about the report overall and even just this particular passage is that what the UK is particularly concerned about is not can we detain all the people we need to detain, at least not in this report. They're concerned about inadequate procedural protections. In other words, are these people getting enough rights? Now, It may be that what's really motivating the administration's concern is that we're not providing people enough rights who we're currently detaining. Their litigating and policy positions might suggest otherwise. But if that's really the U.S. or administration concern, then there's certainly no obstacle under international law or anything else, the administration providing more detailed procedural protections to people who we have in custody in any capacity, and we have any number of models, both international and domestically, for thinking about how to fill in those gaps. I would argue that international human rights law, in particular the ICCPR, and critically, and David Cole can, I'm sure, talk about this in more detail, domestic criminal law, come in to fill whatever gaps might remain open procedurally as a matter of international humanitarian law, that is the law of war. In the meantime, we also have initiatives by the ICRC, the International Committee of the Red Cross, who is more or less the authoritative interpreter of the Geneva Conventions, who has issued in the last couple of years a set of best practices guidance for states that are engaged, whatever the legality, in some form of detention that may or may not fit squarely within the traditional understanding of the law of war. Here are a set of procedural rules we think are best practices for states to follow. So there is certainly no obstacle to the United States or anybody else pursuing that. Second, there's a lot more to say here, but I want to make sure other people have plenty of time to speak, so I'll hope there are questions. Second, just on the question of detention, does international humanitarian law, the law of war, those are generally used synonymously, provide the United States or any other state enough power or otherwise legitimate authority to detain everybody we might need to detain? Particularly, this comes up in the context of terrorism, counterterrorism. And there, I would say, first of all, international humanitarian law provides rather broad powers of detention, or it contemplates broad powers of detention, certainly for combatants, anybody directly engaged in combat, and that is certainly the subject of debate what that means, but it I think, reads fairly broadly. And even under the Fourth Geneva Convention, where the security of the detaining power makes it absolutely necessary. So there is a rather general catch-all contemplated set of detention powers under the Geneva Conventions. And so who does this leave out? And I think really the only two categories of people we might want to detain this leaves out are two. People who are not involved in armed conflict in the sense this term is meant under the law of war, but who have done something wrong. These people, I understand, are called criminals, and under the domestic law of many states, including now the rather enormously broad domestic criminal law of the United States, which now, particularly post 9/11, has numerous criminal statutes of extraterritorial scope, that ends up encompassing a fair number of people. And then finally, and this really is the most complicated category, and I expect we should talk more about this, people who aren't engaged in armed conflict in any sort of traditional sense. They haven't actually done anything wrong or not anything we can prove, but we are deeply suspicious that they may do something wrong. The classic example of this is somebody who is an avowed al-Qaeda member. Now, what do we do with this person? This, to me, is certainly not just a question of international law. My evaluation is that international law can't give the President of the United States, for example, power he doesn't otherwise possess under the Constitution. But that I think there are, if not legally, enormous strategic questions about whether or not we want an international or domestic or any kind of detention regime that contemplates the broad detention of people who are, in essence, mere members of an organization where we have nothing further to prove. And again, criminal law reaches quite low in terms of quantum of proof required that might justify detention these days. I think it is a enormous strategic mistake to engage in the detention of mere members, in part because, and here I'll conclude, if you have, for example, somebody who would be willing to drive a truck committing suicide into a building and thereby exploding a bomb or any other spectacular act of suicide or non-suicide terrorism, this person is, as the hearts and minds argument that the administration makes reminds us, interchangeable. That is, there are many such people out there who might be willing to do that. And what would persuade them one way or another are hearts and minds arguments or senses, not necessarily are you going to pick me up for a little while or not. And there, I think, we end up doing more damage to our Hearts and Minds campaign than we do tactical success in preventing any individual act of terrorism to pursue detention writ large in that way. I'll conclude.
Thank you. Professor Solis?
I'd like to echo Deborah that I'm honored to be up here. The Geneva Conventions are like the silk suit I bought in Hong Kong 5 years ago. It's a hell of a suit, but it's a little tight right now. Doesn't fit real well anymore, but there's a lot of good life left in that suit. And it's the only suit I've got. Now, I've got a sport code, an additional protocol, but it's not the same. And we need to remember that the purpose of the Geneva Conventions is not to provide rules for contemporary conflicts, not to provide rules for detention. The purpose of the Geneva Conventions is to protect the victims of war, the wounded, the sick, the prisoners, the civilians. So we shouldn't look too far. We shouldn't be too critical of Common Article 3 and its somewhat ambiguous language. I mean, we're all students of the law. We're familiar with the term reasonable. We're familiar with the term excessive, suspicion. These are terms that we're arguing about for the last 100 years and will continue to argue about. And so it is with the law of armed conflict. The Geneva Conventions depend upon their application for the good faith application of those who have ratified, every nation on the face of the earth. So we should not expect better bread than is made of wheat when we're looking at the Geneva Conventions. They're pretty good. And I think that they do meet the needs, Common Article 3, of today's non-state actor combatant. One of the problems, I think, today is that, particularly in regard to Guantanamo, we, the U.S., tend to play a little three-card Monte. The first card is the military model, military commissions, law on terrorism, unlawful enemy combatants. The second card is the law enforcement model, detainees, the Covenant on Civil and Political Rights, human rights law, habeas corpus non-availability. And the third card is the mixture of the two that we apply when it's convenient. So we complain that detainees seek rights that not even POWs get. Yet, while denying the rights of POWs, we also deny the rights of civil prisoners, citing their unlawful enemy combatant status. A bogus status, by the way. That's another story. So, if we complain then about how vague Common Article 3 is, well, let's read the commentary to Common Article 3. It provides a lot of help. Let's read some of the decisions of the ICTY, which decisions, by the way, make clear that at least for the ICTY, Common Article 3 is customary international law. Let's read the opinions of the European Court of Human Rights. Now, I realize that these are not binding on the United States, but certainly they should be persuasive and give us guidelines. So I think that not only are the Geneva Conventions continuing to be applicable, but I think they remain excellent guideposts. As for changing them, well, in 1977, when we tried the additional protocols, we got slapped around by the Lilliputians, where Liechtenstein's vote counted the same as the UK's vote. I don't think we're going to go that route again. We've still not ratified those two protocols, as you know, which we have signed, although that's irrelevant because we are bound by the protocols today just as effectively as if we had signed them. So how do we do it? Well, I think we know how to do it. And it's already been mentioned by John and by Deborah, and that is multinational treaties, Article 98 type treaties. We know how to get our way on international treaties. Let's make some international law through international treaties which modify, clarify, and define some of the issues which we're concerned about in regard to Common Article 3. So, as Deborah said, what constitutes taking an active part in hostilities is an issue of continuing debate. Article 51.3 isn't clear. Well, let's see if we can clarify it. The Geneva Conventions remain applicable, they remain good, and they still have a lot of potential for, in my opinion, fruitful use.
Thank you, Professor Solis.
Yeah, I agree with a lot of the points that have been made already. Let me say, the main question that commentators, scholars, policymakers have focused on over the last few years, really since September 11, 2001, has been the issue of treatment standards and what treatment standards would apply to captured suspected terrorists, especially when it comes to interrogation. I think after some muddying of those waters, the law in that area has been largely clarified, both as a matter of international law, as a matter of U.S. domestic law. There's still some more work to be done there, but at least I think there's a lot of fairly clear law already out there. I think where the gray areas remain are on the questions that I would just label quickly: whom, how, where, and when it comes to detention. And what I mean by that, the whom question is assuming that there's some category of individuals who can be detained outside of regular peacetime criminal justice rules, but don't meet the definition of traditional professional army combatants. How do we define this class? The how question is by what rules would we adjudicate the factual determination of whether an individual falls into this category that we would define. The where question concerns where geographically, territorially does this new conflict exist. And the when question is the duration question. How long do these detention powers exist? When ought the state's coercive authorities over a particular individual expire? And I think the law of war doesn't have a lot to say about any of those questions, at least as it's currently constructed. I think it sounds like there's pretty wide agreement among the panelists, perhaps for different reasons, though, that the solution to this is not to negotiate a new Geneva Convention, a fifth Geneva Convention. And I agree with that. In addition to the difficult problems that John raised of sort of how do you garner agreement among 194 different countries, I think there are some basic problems that just result in too wide a gap between the positions that the participants in such a deliberation would come to the table with, including a basic disagreement about whether or not we should think about this detention problem as stemming from a conflict or a war at all, or whether we can solve this problem through application of criminal law. I think there's a difference. I think anytime we talk about designing new rules for this new type of conflict that would presumably apply to let's say transnational terrorist organizations, we get in the very, very politicized question of how do we define terrorist. There's a question, I think there'd be deep divisions about what law already applies, and the fact that, for example, the United States and Europe have different legal obligations as a result, for example, of European countries being party to the European Convention on Human Rights, which would result in different starting positions. So I think the idea of negotiating a new Geneva Convention is probably not the solution. I do think that we need to come to some, and quite urgently come to some agreement with especially our closest coalition partners in combating al-Qaeda. And I think perhaps a better approach would be to come up with a set of protocols or standards for handling the type of individuals who we, the United States, have so far regarded as unlawful enemy combatants in this conflict against al-Qaeda. And I would articulate this as a set of protocols or standards governing the disposition of these detainees, which would apply at least as a matter of sound policy. Perhaps some of them would also apply as a matter of law, but in order to gain some basic agreement agreement on these rules, I would probably articulate them as applying at least as a matter of sound policy, because I agree with the point that Jack Goldsmith made earlier that a profound strategic error on the part of the Bush administration has been to overvalue the strategic benefits gained from wide operational flexibility when it comes to detention and interrogation, and to undervalue the costs of these expansive interpretations and wide executive flexibility, underestimate those costs to effective multilateral cooperation in combating terrorism, as well as the cost to our other foreign policy agendas, including promoting human rights, including promoting good systems of governance abroad. So I think there's a lot of urgency in trying to reach some basic agreement on not just the treatment standard questions, but the other ones I mentioned, the whom, the how, the where, and the when, the duration questions, especially with our closest allies pretty quickly. I think this will be a project for the next administration. All three major presidential candidates have at this point seemingly embraced this sort of ideological shift of recognizing that our current approach sort of runs to our strategic detriment. They've all, for example, pledged a commitment to closing Guantanamo, but talk is cheap when it comes to Guantanamo, and it'll be very interesting to see what type of concrete proposals they come up with.
I want to say, first of all, how honored I am to be on the panel, and how honored I am to have Neil Katyal as a colleague at Georgetown Law School, and to have the Center for National Security and the Law, which I think has already shown tremendous insight by hiring Matt Gerke and Justin Florence as the first interns, tremendous fellows for the program. And then finally, how honored to have Paul and Patricia Saunders endow a chair for Neil. So that said, let me talk a little bit about the questions that John has raised, and I think that the real problem here is the motivation behind the questioner, and I don't mean John personally, but I mean I don't know what his motivations are, but it's clear what the United States' motivations have been, and they have not been, as Deborah's first comment suggests, they have not been, we need to gin up the law of war so that it protects those who we detain from us. That has not been in any way, shape, or form the motivation behind the questions. And so just think about, for a moment, just to put this in context, and think about how the rest of the world responds to these kinds of questions when they're raised. Think about the answers that the administration gave to these questions that John raised. Who is a combatant? A little old Swiss lady who donates money to an institution that turns out to be funding Al-Qaeda is an enemy combatant, according to the administration's own lawyer in court. The definition of enemy combatant has been, as they have articulated it, is extremely, extremely broad, beyond anything that anyone would ever agree to in any kind of multilateral process. Second, what process are they due? Right? This is a hard question, because you're in the chaos that is Afghanistan, and you're picking people up and they're not wearing uniforms, and so how do you know whether you're picking up someone who's actually a combatant or someone who's a farmer or a shepherd who's been turned in by the Northern Alliance for a bounty? And the administration's response to that was no process is due. Literally, no process is due. That was the administration's initial position, right? We determine who's a bad guy, as President Bush puts it, and then that's the end of it. There need be no hearing whatsoever when they lost in the Supreme Court on the position that these people have no rights and even no opportunity to come to court. They then hastily put in place an incredibly kangaroo-like process, which has been rightfully condemned across the board. And then the third question, how long can we keep them? It's a good question. Tough to define when the conflict with al-Qaeda or the Taliban is going to be over. But what was the administration's initial response to that? Until the global war on terror concludes. And how do we define what the war on terror is? It's not a conflict with al-Qaeda. That conflict, I think, will end. I think that in our lifetimes, the conflict with al-Qaeda will be history. But the conflict defined by the president as a war on all terrorist organizations of potentially global reach will never end. And so you had the administration saying, we can hold little old Swiss ladies without giving them any hearings whatsoever for the rest of their lives. And so you do have to wonder about the motivation behind the questioner. And I think given that that was our starting point, and that we have only pushed back from that starting point, kicking and screaming as a result of incredible resistance from civil society organizations, from the courts, from the international community and the like, one has to look on any U.S. effort here with tremendous skepticism. And then let me just say one word about the question that John didn't ask, which is how do we treat them? And I think he didn't ask that because I think Common Article 3 is pretty clear about how we treat them, which is that you have to treat them humanely. You can't subject them to any cruel or abusive treatment whatsoever. And yet we know that our administration took the position that we could subject Mohammed al-Qahtani at Guantanamo to 100-plus days of 20-hour-a-day interrogation in which he was stripped naked, forced to wear women's underwear, threatened with attack dogs, forced to bark like a dog, and injected with IV fluids until he urinated on himself. And we know that the administration interpreted that on reviewing that interrogation as a humane treatment. So it's the question is whether we are in good faith answering the questions in the way that the rest of the world would do. And we also know that this is not just a matter of history, that the administration has continued to insist on the right to disappear people into CIA secret black sites and to use coercive tactics against them. And we learned yesterday that these coercive tactics, which have in the past included waterboarding, have been approved in a situation room by personally Vice President Cheney, Attorney General Ashcroft, Condoleezza Rice, and Colin Powell. So this is not some low-level Abu Ghraib-like out-of-control policy, but it is the highest, the people with power, and the only person who wasn't in the room was George Bush, deciding specifically how that we can employ these kinds of inhuman, clearly violation of Common Article 3 kinds of tactics against disappeared suspects. And so, we just start from a tremendous, tremendous hole. And the next administration will have a little bit of space, but I think it's going to have to take some dramatic steps to begin to shift the perspective that the world has on how the United States has come to answer, to ask and answer these questions.
I'd like to give Mr. Bellinger an opportunity to respond to some of that. But in particular, I think there's some consensus about what the questions are at this point, and I'd be interested in hearing what Mr. Bellinger has to suggest for, and the rest of the panel has to suggest for some of the answers to these questions. Whom can we detain and how long? So.
Great. Thanks, Matt. Well, that, I think, was the question to the panel. David, who I've gotten to know quite well, and who we've had this debate. The question for the panel was not the questions about secret detention and torture and rendition and various other things. I mean, part of my job at the State Department is to go around the world answering these questions. I'm happy to do those. But the question that we're addressing here narrowly today is do the Geneva Conventions and, if not the Geneva Conventions, international humanitarian law provide the answers that a country needs in terms of the detention and treatment of individuals in a conflict with a non-state actor. And that, I of course know that there is enormous disagreement with Bush administration policies on all of the things that David mentioned, that there are questions about motivation, but this is a law school. We are inaugurating a new center to study legal issues. And so what I really would like to do is to challenge the lawyers in the room to sort of put aside the inflated rhetoric. I understand when there are suspicions about motivation that you don't even want to get to the questions, but to look at, are there difficult questions? And so, if you look at the other way and the suggestion is no, there are no questions here, everything is already clear. We know, even in a conflict with non-state actors, we know how long we can detain someone. We know how long the conflict ends. We know who is a combatant. We know what process we need to give them. We know what country we return them to. Then we have no problems. And the Bush administration should just follow those clear rules and everything would be fine. That's not the way things are. I do know the suspicion is that when we ask these questions, it's because the administration wants to weasel out of the rules. But the fact is, I agree actually with Professor Solis that the suit of clothes that we have in the Geneva Conventions is an excellent one. Our military, who we talk to every day about these things, is very comfortable in that suit. But it doesn't, in fact, provide all of the answers to us on some of these questions that I have outlined. We really do need to focus, and it's not, as Deb suggested, that we are looking for new rules so that we can do more. It is really, we're looking for rules so that we know what the rules are. People regularly say, you are violating the rules. You are violating international law. I can tell you through 3 years of discussions with Europeans, when I say, all right, you say we have violated the clear rules, what are those rules? And I've lined people up and they give me 25 different answers on, well, we think the Geneva Conventions clearly apply. No, the Geneva Conventions don't apply. It's all criminal law. Criminal law applies. No, we think that human rights law applies. It's because there is a desire for there to be clear law that applies in this area, because people don't want there to be gaps in the law. That's not a comfortable policy or legal position for all of us to be in. But sometimes the law doesn't give you clear answers to the questions. Now, I think it's a fair criticism to say, well, if the law doesn't give you a clear answer, then you should have better policies. And you can be critical of policies. And certainly the administration has made many mistakes. But that's often not the criticism, and that's why I say this to a legal audience. It's not just that you've made mistakes in policy. It's the law was clear. There are no need to reform any of the laws or even to ask what the gray areas are, because the law was clear all along. And that's the question that I put to you, to the lawyers in the room, to answer. Are all of the questions already answered? I think, and I don't want to put words in Professor Solis's mouth, that he agrees that there are some gray areas of unanswered questions. Our motivation is not to try to get out of the law to give us more freedom of action. It is simply so that we can agree with our allies around the world on what the rules ought to be for who can be detained and how long we can detain them. And I will just end by saying that no, I am not aware that we are holding any Swiss grandmothers who have contributed to Al-Qaeda, and I will go and make sure of that when I get back. Thank you.
So just to sort of push forward and try and give Professor Solis a new suit, how can we start answering these questions? I mean, if we want to start to answer these questions, the whom can we detain? I mean, I know that Professor Waxman has thought a lot about this. Do you have any suggestions as to what we can do about answers to these questions? I mean, obviously the big question is whom can we detain, but what's the answer to that question? Do you have any thoughts?
Sure, we can detain anyone who takes unlawful combatants in a common Article II armed conflict between two or more states. In a common Article III armed conflict, we can detain anyone who takes an active role in hostilities who is not a combatant. Someone who takes up, a civilian who takes up arms and engages in hostilities may be detained. In my view, there are far too many people detained on far too slim bases, and that provides some of the problem we have. We have so many detainees now that there's no way that the civilian courts, domestic courts, could handle them all. For that matter, there's no way that they could be handled by a military court. And of course, we're never going to try anybody down in Guantanamo. No one's ever going to be convicted after a full trial in Guantanamo. You heard it here first. And I think we realize that even at Guantanamo, we're only going to try, if anybody, there would only be 10 or 12 that would ever be tried. So we're holding far too many people on far too slim a basis, in my opinion. But there is a basis, I think, for determining who we can hold.
Okay. Professor Cole, did you want to?
Yeah, I actually think that had the administration taken more reasonable positions with respect to the questions John asked, that we would not be in the situation we are today. That is, I don't think the world finds it outrageous that we responded with military force to al-Qaeda after we were attacked. 120 nations signed on to our efforts in Afghanistan. The UN and NATO both described the attack as one that gives rise to the right of self-defense and the right to respond militarily. And so on that point, I don't think the world takes issue. On the point that when one is in a military conflict, one can hold those who are fighting against one for the duration of that conflict. I don't think the world finds that to be an outrageous or novel proposition. That is sort of the bedrock of the law of war. It's all about how we detain and how we treat those who are detained, but it presumes that you can detain them. And I also think that it's fairly clear that you can hold people for the duration of the military conflict. And had we taken those positions, had we said we're only going to hold those who are actively fighting against us, we're going to provide hearings so that we can in fact fairly determine who is fighting against us and who is not. And we're only going to hold them for the duration of this particular conflict with Afghanistan and al-Qaeda. I don't think Guantanamo would be the international embarrassment that even President Bush today agrees needs to be closed because it is doing so much harm to us around the world. So, John, I think John accused me of inflated rhetoric. I don't think I was using inflated rhetoric. I think I was describing the administration's positions, and the administration's positions are inflated, yes. And so I suppose the rhetoric that describes that view of a nation's power might be described as inflated, but it's only because it's describing the facts. It seems to me that the questions can be answered, but if we wanted to take a leadership role in how to answer them, then we ought to be putting forth very specific, narrow definitions. We ought to be providing very fair, scrupulously fair process, and we ought not be saying that this is a war that will last until every terrorist organization with potentially global reach is eliminated from the face of the earth. And so, I agree also that some of these questions are difficult, and that it's not all, at the margins things are unclear. But what is clear is that every one of the administration's answers to these questions has been wrong, and clearly wrong, and I think seen as clearly wrong by the rest of the world.
David, I would never accuse you of inflated rhetoric.
Oh, good.
I was trying to get you to stick to the subject at hand. Which,
and I thought I was.
Are there clear rules that give the administration answers? And, like questions of, well, it's clear that someone has a gun in their hand as a combatant. Is the person who builds the bomb or puts together the gun to give that person, is that person a combatant or not a combatant? And these are more difficult issues in the day when your combatants don't come at you all with uniforms on.
I guess I would say just a couple of things. One is, with respect to the relationship between the record of detainee treatment and torture in particular and the questions of the questions of detention going forward. It is legally possible, but practically impossible to separate them in the realm of talking about whether we need a new international law going forward. And what I mean by that is this. The reason, as I understand it from the UK parliamentarians who've written and spoken about this, that the UK, among others, has balked at engaging in covert counterterrorism operations with the United States in various contexts is because they're afraid we will torture the prisoners, among other things. So that leads me to the second point, which is this, and again, in the context of responding to the do we need a new international law for 21st century conflicts? We have never been in a weaker position as a nation to embark upon the international negotiation of an instrument in this subject matter. And it is because of actions that we've taken in the last 6 to 7 years, and in some respects a little bit longer. I would not say that international humanitarian law, or indeed the Due Process Clause, is without questions or is written with perfect clarity. And indeed, on two particular questions, what it means direct engagement in combat, and what it means, the security detainees under Geneva IV, how often do we have to review their detention? What do we have to give them? Are they entitled to some sort of representation? What kind of evidence are they allowed to talk about? The law of war, the text of the Geneva Conventions, leaves that without the level of detail I would like. But from the position of the United States in 2008, 2009, to say next step solution is let's engage this internationally and negotiate internationally, I think is the wrong next step. I think a more likely to be effective and well-received next step, one that is more likely to promote our tactical and strategic interests critically over the longer period of time, is a unilateral step by the United States. And it is a unilateral step that undertakes to define, for example, the gaps or the lack of clarity in those specific areas in a way that is as favorable to the rights of individuals as we can plausibly provide. And I think that we have not done that. I think it is entirely possible to do that. And I think before we can re-engage internationally in any meaningful or constructive way on these questions, we have to be prepared to take that initial step.
Thank you. Matt Waxman has said that the treatment standards are clear. Ms. Pearlstein is arguing against the treatment standards that we are currently employing. And I guess looking forward to beyond this war, beyond the war on terror and to future wars, potentially against a peer rival in China or a near-peer rival in China or a small country armed with weapons of mass destruction, to what extent does the reinterpretation, if I can say that, of the laws of torture, to what extent will that impact American interests in the next conflict? I mean, if I know that Mr. Bellinger, you've declined to comment on whether it would be legal for another country to waterboard American soldiers. What do you think about the precedents that we're setting today for the next conflict?
I guess a couple of points there. Certainly the actions that the United States takes around the world have an enormous impact. In that we have traditionally been a leader in the rule of law, in international humanitarian law, in the development of law relating to armed conflicts, in part because we tend, as a superpower, to have gotten into a lot of them over the years. So people do look at what we do. One of the parts of the dialogue that I've had with the International Committee of the Red Cross is they are, in fact, very concerned, I think as someone said, as they are sort of the keepers of the Geneva Convention, the interpreters of the Geneva Convention, and they want to ensure that those do stay as bedrock principles. So we try to be careful to say we are absolutely committed to the Geneva Conventions in applying them in as robustly as we can to the conflicts that they apply to, but at the same time trying to work together with other countries to fill in the places that they don't apply. I think I take Deb's point that it's hard for the United States, and again, I try to be candid about this. I mean, we recognize the concerns about U.S. policies and U.S. legal positions around the world, and it is hard for the U.S. to be engaging allies when questions have been raised. But obviously, the answer can't mean, well, we're just not going to go and engage our allies. We're not going to go and talk to them. One of the lesser-known recommendations of the 9/11 Commission, Dan Marcus here in the room, Deputy Staff Director of the 9/11 Commission, now Professor at AU, was that because of the haziness with respect to the legal framework applicable to the detention and treatment of detainees, that we should engage our allies around the world to try to clarify what those rules are. Congress subsequently passed a statute requiring us to do exactly that. And I now spend a good part of my time as legal advisor at the State Department, in fact, engaging our allies and non-allies around the world in these discussions so that we can, in fact, clarify the rules. Now, we have tried. Deb's point is, don't just go out and try to agree, but demonstrate leadership. Try to take unilateral actions. And while it's been perhaps slower than a lot of us would like to have us take those actions, there has been an enormous evolution and progression in U.S. policies in the last 3 or 4 years. It's not fast enough for many people outside the administration. It's not fast enough for many people inside the administration. I think most people know now that there have been great debates inside this administration amongst its policy people and its lawyers about what the rules ought to be. And for many people, it's not. We have not moved fast enough. But we have developed, in fact, new procedures, new rules. David suggested that, well, it ought to have been clear that when we captured someone that we needed to have some sort of a clear process to determine whether they're a combatant. Well, I can tell you the reason that wasn't done. In retrospect, it looks clear as day that it was a mistake. But if you generally follow the old rules, which is when you capture a combatant in a conflict, that you simply hold them. You don't have to have a trial for them. In a traditional kind of conflict, again, with someone with a uniform on, you just hold them because it's clear that they're a combatant, and you wait for the war to be over, and then you can return them. This has posed new challenges for us in determining with people who don't have uniforms on, and it's not clear precisely whether they were a combatant or not. Now, maybe it should have been clear as day at the beginning that if someone didn't have a uniform on, even if you captured them with a gun in their hands in Afghanistan, that you needed to have some kind of a trial for them to determine whether they can be held. And maybe it should have been clear exactly that when the conflict ended in Afghanistan, that the conflict therefore ended with al-Qaeda. But those things were not clear. Again, mistakes have been made along the way, but it's not that there were clear answers. There was not, as some have suggested, a book on the shelf that gave an answer to every one of these questions back in 2001 and 2002.
Go ahead. Oh, no. I was just going to say, one point that I would just add to the list of missed opportunities has to do with, and this really combines some of John's points and some of Deborah's points, has to do with the missed opportunity on the part of the United States to contribute some clarity to some of the gray areas of the law, perhaps through, at least initially, our own unilateral steps. When I said before that I think the law of treatment is relatively clear, what I meant is there's a lot of pretty clear text. We can, at this point, there's a lot of agreement on the words that apply. There's not always agreement on what those terms mean. When it comes to a prohibition on degrading treatment, I think we'd all here agree on certain things that are clearly off the table, but around the margins, we would have some disagreements on exactly where we would draw the line. When Article 5 of the Third Geneva Convention talks about having a status determination by a competent tribunal, we'd have some disagreements about what would constitute a competent tribunal. And one of the missed opportunities by the Bush administration has been that by declaring these textual provisions inapplicable, saying that certain treatment standards don't actually apply or the Article 5 tribunal requirement doesn't apply, we've missed an opportunity to put forth through state practice what we believe constitutes adequate treatment or adequate process. And so I think there is a lot to be said for what Deborah talks about as unilateral steps, if we can do it in a way that I think contributes to a clarification of some of these rules that we might agree apply as a matter of text, as a matter of treaty law, but in their application to this new type of conflict don't really have a lot of clear meaning.
I think it's not just a matter of missed opportunities, which it obviously is, but it's also a matter of a need to set the record straight. One way of thinking about it is, how would we think today if Russia or Uganda took the position that it could disappear American suspects into secret prisons and then have its vice president, its attorney general, its secretary of state, and its national security person sit in a room and authorize coercive interrogation of those suspects disappeared and held incommunicado? How would we feel about that? And I think we would not feel very happy about that. And I don't think the world feels very happy that we're still essentially asserting that right. The CIA black sites have been reopened. When Common Article 3 seemed to pose a problem with respect to that, we got Congress to water them down, or to water down the criminal provisions that are triggered by Common Article 3 violations so that we could reopen the black sites. And then we announced we've reopened the black sites. And then we issued guidance to the CIA interrogators that essentially continue to allow them to use coercive tactics while assuring people that we're no longer waterboarding. I just think that it's not just a matter of missed opportunities. It's a matter of having to take account for what we have done wrong. It's a matter of requiring some sort of truth and reconciliation, of holding people accountable in a public way. And until we do that, we're not going to be able to build the trust and the confidence that we need in order to begin to even start trying to work multilaterally towards answering the questions that John asked.
We need to start on this rehabilitation effort, if that's the word. We need to start looking for answers to these questions, because we need to remember as well that what goes around comes around. And there are some military people in the room, and I know that in my 26 years as a Marine officer, when I was in Vietnam, I was always afraid of being captured because I knew how they treated captives. And today I ask myself, how the hell did we get here where they're afraid of how we will treat them?
And I guess that's sort of relevant when we're looking forward, again, not to this conflict, but to the next conflict. It may seem justified to many of us to treat harshly captives of a force that would treat us harshly were they to capture us. I don't think anybody expects Al-Qaeda to treat American soldiers with any sort of rights. But if we were to get into another conflict with a state actor or a quasi-state actor, I think there's some concern that we might be subjecting our own soldiers to, for instance, waterboarding and that sort of thing. So maybe you'd like to respond to what sort of looking forward at a conflict potentially with a near-peer rival or a conflict with a nuclear-armed North Korea or nuclear-armed Iran. What sort of rules would we want to have in place? How would we want to change this, not just for the current conflict, for the war on terror, but for the next conflict?
Well, I think we've been pretty much discussing that, which is, we need to have we need to all of us try to work together to come up with some clearer rules. We need to try to agree internationally on what those rules are. There's going to be disagreement on some aspects, but particularly with our close allies, and I gather Jack Goldsmith said this earlier today, that it is important with our allies that we have some agreement on what those rules are. That is really what we have been working on at the State Department for quite some time.
Anybody else? We can open it up to questions. If anybody in the audience has questions, you can feel free to come up. Would you like to come up to the microphone? You don't want to come up to the microphone? It's right here, sorry.
I can hear Marty.
I was going to say,
everyone can hear Marty, but
you don't have to go to the microphone.
But it's for the rest of the.
I wanted to suggest, I suppose, that David's questions actually are more tied to the questions that John was asking than they led on. But at the same time, David, I think they might reveal the uncertainty of international law with respect to the questions John asked. And why has the Bush administration taken all these views that David describes? I don't think it's simply hubris or Dick Cheney's view of presidential power or unilateral authority. I think the central reason for every single thing you ticked off was that the primary reason for our detention policy here, not exclusive, but primary reason, is not incapacitation, but interrogation and intelligence gathering. That's why we have to assert the power to detain the little old lady. It's why we have to have black sites. It's why we have to use these coercive interrogation techniques. That's the executive branch's view of things. And I thought it was really interesting. This week, two things happened to reveal the breadth of the administration's theory of who they could detain. One was the theory in the Parhat oral argument about their authority to detain people who are very attenuated with very attenuated connections to Al-Qaeda, who are terrorists in in a very different sort of conflict. But more importantly, in Jeff Toobin's New Yorker article, the naval head of the CSRTs at Guantanamo, in explaining why, what questions they ask in terms of why do we continue to detain people at Guantanamo, was anyone who is determined to either continue to be a threat or who has intelligence value will be continued to be detained at Guantanamo. And so here's the question with respect to international law. Given that I think so much of this is driven by a need to detain for intelligence gathering, and in particular through coercive interrogation, does international law have anything to say about the power to either to authorize or to limit that kind of detention? I'm not sure it does. I'm not sure it either has things to say on the authorization or the limitation side, but I'd be very curious to know whether any of you thinks otherwise, and if not, what do we do about that if that's really our goal?
Well, I mean, there's often sloppiness in rhetoric as to exactly what legal rationales are. I mean, one of the things that we have tried to do, at least the State Department, is to try to go out and speak more publicly about the legal rationales for the positions that we've taken. I mean, under international law, you can't detain someone just because you'd like to question them. You can detain people in an armed conflict if they're a combatant in the conflict. Now, it's often that someone who is a combatant in the conflict also has intelligence information, and that therefore it is a priority for you to get the intelligence from the person who is the combatant. But you can't just detain someone because they have intelligence if you don't think that they are a combatant. Now, the difficult question, and I think I at least hear some agreement around the edges, that it is difficult to determine in a conflict with a non-state actor as exactly who the combatants are, who is taking a direct part in hostilities. That is a question that the ICRC, in fact, has had a study group on for several years amongst experts around the world, and there is vast disagreement, and not just disagreement between the United States and the ICRC, but amongst all of the participants in who you can even define in the modern age, which sort of gets to part of Matt's question of who is a combatant.
I would just say, number one, I just agreed with everything you said.
Peace will break out at the end.
I'm appalled to say. No. In particular, 2 points, and then I want to have a different response, a different go responding to Marty's question. In particular, number one, it's not as easy either under international law in international circumstances or under domestic law in domestic circumstances to entirely separate the purpose of detaining for prevention and the purpose of or punishment for that matter, and the purpose of detaining for the purpose of information gathering. So I don't want to. I don't want us to oversimplify that dichotomy, or for that matter, the motivations of people in the administration who were responding to it or not. Second, international law wouldn't allow for the detention of people just because I think Marty has something interesting to say and I want to know what it is. I do think international law has something to say about how I could treat you if I were detaining you for those purposes. But, I think there is now substantial, although not entire, consensus on what that is. With respect to the policy motivation of wanting to detain people for the purpose of either coercive interrogation or let's set aside all questions of coercion for the moment, just custodial questioning. My strong impression is from speaking with people in the intelligence community is that we pursued that as a primary source of human intelligence because the best sources of human intelligence we were entirely without. That is to say, actual, in the Soviet days, you used to call them moles, but that's what we're fundamentally talking about. My hope and expectation is that starting on September 12th, 2001, our intelligence community prioritized the better and less rights, not entirely rights neutral, but less rights intensive forms of human intelligence gathering than locking somebody up in a room and interrogating them. That's one. Two is, in speaking with the intelligence community, my impression is this: to the extent custodial detention for the purpose of information gathering, setting aside international law, because I just don't think you can do it, under constitutional law, U.S. constitutional law, would be permissible. I think it would have to be clearly for a remarkably limited period of time. That's on the law side. On the policy side, from the intelligence community, I hear if you're not using coercive means, because almost none of them I've spoken to, maybe it's just because I don't talk to the right people, think that coercion is much use, or at least reliable use. If you're not using that, what you need most of all is time. That is, if I have enough time to develop a relationship with a person, as I might have at pretrial detention, for example, then I can develop, and we have indeed in the prosecution of the first World Trade Center bombers, for example, a remarkable amount of excellent human intelligence out of those interviews, then we can develop really useful intelligence in a kind of regime that might be arguably constitutional. Hold them for 48 hours, hold them for even, and I think this is at the outer limits and probably unconstitutional, 24 days. I don't think they would say that's going to be of much help. Now, maybe we need a next conference to figure out the answer to that question.
Can I just say, in response to Deborah's first point, that the last person in the world that you'd need to detain to find out what he has to say is Marty Lederman.
Well, are there any other questions from the audience? Please come up if you want to line up behind it.
Yes, this is just a question for, I guess, anybody can take this if they want to. We are harping a lot on definitions of who is a combatant, who is not a combatant, but these are essentially field decisions that are made on the ground itself. It wouldn't be a more productive use of our time to actually try and provide consensus internationally about the adjudication process that's made on the field?
The answer is yes. I mean, I don't know. We are doing that. I wouldn't say that you can't focus on what the field decisions are as well, because the field needs guidance from headquarters. I mean, essentially, one reason that we have the people in Guantanamo is that they, in fact, were screened by multiple levels in the field, and determinations were made, not by policymakers in Washington, but by people in the field, that these were people who ought to be detained. Now, of course, through thousands of hours of discussion, I can tell you I'm well aware of different allegations that this person was a shepherd and this person was in the wrong place at the wrong time. But those were field decisions that those people were picked up on the battlefield. Now, what we have been trying to agree on is if in a traditional kind of conflict, you hold a prisoner of war, they do not have a process to determine whether they're a combatant, but in a new kind of conflict, everybody agrees that mistakes can be made and there should be some kind of process to determine who is a combatant, then what ought that process to be? Some people will say, well, there needs to be a full-blown criminal trial of absolutely everybody who you hold, and they should have a lawyer, and evidence should be presented, and you can't hold them unless you essentially have a criminal trial. Well, you can imagine if you detain hundreds, if not thousands of people in Afghanistan by your soldiers, and the legal presumption is you cannot hold that person unless you have a criminal trial with evidence that will stand up with a lawyer to defend the person, that will be very difficult to do. So we are, in fact, trying to work at the international level to determine what is the amount of process in a new kind of conflict to determine is someone worthy of being detained. I think everybody agrees that there needs to be some sort of a process, and the question, though, is how much process is due. And I think Jack probably talked about it. If he didn't talk about it, it's been in his book that there's growing convergence. The United States has been providing more and more and more process as it recognizes that, in fact, it is in a new kind of conflict, whereas many of our critics are, in fact, recognizing that this was not quite as easy as maybe they thought, that the rules were not quite as clear, and that the United States hadn't just gotten it all wrong, and that there are difficult questions about who can be detained. So at the international level, yes, absolutely, we are having precisely that conversation as to what's the amount of process that should be afforded.
Matt, did you want to address that as well?
Yeah, I would just say we keep coming back around to this question of whom can be detained, especially, for example, if we do believe that this is an armed conflict against Al-Qaeda and that Al-Qaeda fighters can be held as enemy combatants, we need some definition of enemy combatancy. And I think this is an area where international law, as it existed before September 11th, was not entirely clear. I think the Bush administration seized on that lack of clarity to put forth a very sort of over-expansive interpretation of this class of individuals. I agree with I think David's earlier point that not only was it was an overly expansive definition that would include, for example, the little old lady in Switzerland, erroneous as a legal matter, but it was also erroneous as a strategic matter, especially as a litigation strategic matter. But then there's the question of, well, how should we narrow it down? And there are a number of standards out there in the international legal discourse that you might use. You might say, well, it's sort of a membership test. But, well, membership makes sense certainly with regard to professional armed forces who wear uniforms. Membership is easy to determine. But in the case of Al-Qaeda, while membership is easy in some cases, individuals who swore declarations of fidelity to Osama bin Laden, that might be a pretty easy case. But Al-Qaeda members don't generally carry sort of membership by identification. So that test doesn't really work. There is another test in international law of combatancy that has to do with direct participation in hostilities. But this doesn't really work in the case of this new type of conflict with a transnational terrorist organization because one's participation in this conflict is difficult to determine. There are a lot of activities that might contribute to Al-Qaeda's agenda. Do those constitute direct participation in hostility? So let's say that none of those tests really work, and we want to come up with a new test. What might that look like? I think a lot of people who advocate legislative solutions to the detention problem want to come up with new definitions of this category of individuals who might be detained. One common suggestion I often hear is that you'd want to come up with certain types of acts that the individual committed, and also have to show some prove beyond some standard that this individual continues to pose a danger if released. That might be the way we would define this class: individuals who committed certain terrorist acts and who would pose a continuing threat if released. And once we have a clearer definition of this class, then the issue moves to process. And I would just say that I think based on the last few years of experience, there are a lot of different architectures one might design for adjudicating these cases. But I would just put forth that anything that lacks certain minimum elements, including judicial review, a meaningful opportunity to contest the factual allegations by the state, and transparency, is anything that lacks those minimum elements is probably not going to be legally durable, politically durable, and strategically or diplomatically durable.
Well, thank you very much. I'm afraid we'll have to break for lunch now, but I want to thank our panelists. It's been very enjoyable. For those of you who are staying for lunch, we have an excellent speaker, Alberto Mora, and it's downstairs next door at the fitness center. Thank you. Thank you very much. I appreciate it.
Well moderated.
Always a pleasure.
Good to see you.
I hope.
Paper.
Thank you very much.
At some point,
Reforming preventive detention.
You have to
On that too.
It may be. It actually may.
And I would like to send you mine.
Yeah, I'm actually quite nervous about it.
Oh, congratulations.
So mine.
Now she's going to go.
Great. You want to just do when I get home? Let's just do a swap.
Yeah,
That would be great. That would be great. And then maybe because sometimes it's easier than just sort of sending back written comments. But maybe we could just arrange it. Yeah, exactly. Yeah, that would be great. I'd like that. Good. My question
we can sequester